Washington, D.C. has some of the strongest tenant protection laws in the country, and landlord entry rules are no exception. If you own rental property in the district, understanding these rules is essential. Welcome to tenantscreeningbackgroundcheck.com. Here's what D.C. law requires for landlord entry. Washington, D.C. requires landlords to give reasonable advance notice before entering a rental unit. While D.C. does not codify a specific number of hours in a single statute, 24 hours is the widely accepted standard, and giving written notice is strongly recommended. Entry must take place at a reasonable time, normal daytime business hours on weekdays. D.C.'s strong tenant protection framework means that entry practices outside of these norms will face serious scrutiny. D.C. landlords are permitted to enter for making repairs or improvements, conducting inspections, showing the property to prospective tenants or buyers, and responding to genuine emergencies. Emergency entry without notice is available for immediate threats to the property or tenant safety. What sets D.C. apart is the strength of its tenant protection enforcement. D.C.'s Office of the Tenant Advocate actively supports tenants in disputes, and the district's housing courts are among the most tenant-friendly in the country. Entry violations can support claims of harassment, and D.C. law provides strong remedies, including damages and injunctive relief. D.C. also has specific anti-harassment provisions in its housing code. Repeated unauthorized entry, or entry used to pressure a tenant to vacate, can constitute landlord harassment under D.C. law, with serious legal consequences. For D.C. landlords, give at least 24 hours written notice, enter during business hours, have a legitimate purpose, and document everything. The legal environment in D.C. demands a high standard of professionalism. For complete landlord resources and tenant screening tools, visit tenantscreeningbackgroundcheck.com.